in a few seconds. We're just waiting to let the participants in from the waiting room. So bear with us for a few seconds and we'll get going. All right, looks like we've got quite a good crowd. Still some people joining us, but why don't we get started with introductions, and by that time I think maybe everybody will have joined us. My name is Steve Wermiel. I am the moderator for today, and I am moderator in my role as co-chair of the ABA section of Civil Rights and Social Justice, Free Speech and Free Press Committee, which is sponsoring this event. We're glad to have you all here. The event, as you know, is the Supreme Court examines free speech, and our aim is to look at several important free speech cases decided by the Supreme Court in the term that ended most recently. Before I forget, let me thank Ali Kilsgard, who is our ABA staff person and who did all the work to make the logistics of this program happen. And much of what happens in the Civil Rights and Social Justice section would not happen without Ali. So Ali, thank you so much. In today's program, we're going to hear from our three speakers and have some discussion of the major cases. We welcome your questions in the Q&A. Please don't put them in the chat. We will not see them as easily in the chat. We will try to answer them in the Q&A. If we don't answer them while the discussion is going on, we will try to leave some time to answer them at the end. So again, please put your questions in the Q&A and not in the chat. I am delighted to be joined today by three extremely well-qualified experts on the things we are talking about today. Alex Abdo is litigation director at the Knight First Amendment Center at Columbia University. Kate Ruane is director of Free Expression Project at the Center for Democracy and Technology. And Darpana Sheth is vice president for litigation at FIRE, the Foundation for Individual Rights and Expression. All three of our guests deal with the issues we're talking about today all the time, and really have extraordinary expertise. And so it's a great honor to have them. And I'm especially honored since I teach law at American University, Washington College of Law. I'm particularly honored to have Kate, who's a JD graduate, and Darpana, who's an LLM graduate. So thank you both in that extra way. The presentation order we'll just go through as we get to the topics. Our plan is to have each speaker present a case for a few minutes and then open it up to discussion among the panelists. And again, we'll try to keep an eye on the Q&A, but we may not get to those until the end. The last thing I'll note is this is just one of many timely and important panels that the Civil Rights and Social Justice section puts on. And so if you want to keep up with this and other issues, consider joining the Civil Rights and Social Justice section to get a good sense of the vast programming that is done. So with that, let me start with Kate, who is going to talk about Moody versus NetChoice.
Thanks so much, Professor Wermiel. It's delightful to be here, and particularly an honor to be in such amazing company. So Moody versus NetChoice. Earlier this month, the Supreme Court issued what I think is a pretty good First Amendment decision in general. Its decision in Moody versus NetChoice, addressing the First Amendment implications of Texas and Florida's social media laws. Unanimous in its agreement to remand the cases to lower courts for further consideration, the court's majority opinion, authored by Justice Kagan, nonetheless provides a roadmap for considering the First Amendment protections afforded to platforms' editorial decision-making in their traditional news feeds and homepage content choices. Beyond that guidance, however, many open questions remain regarding when facial or overbreadth challenges are appropriate, what the court's understanding of AI's role in content moderation really is, and the decision's impact on transparency requirements for social media. So to dig in a bit further, first I want to provide a little bit of background. In 2021, Texas and Florida enacted laws intended to govern content moderation on the largest social media platforms. The laws are similar in many respects, but they differ in important ways. Florida's law broadly prohibits certain types of content moderation, including censorship and shadow banning, and moderation of content about certain topics or by certain categories of speakers, including journalistic enterprises and speech by or about candidates for office. Among other requirements, the law imposes on moderation practices. It requires that all content moderation be done in a, quote, consistent manner. And Florida's law also requires platforms to provide individualized explanations to each user each time the platform removes or alters their posts. Texas's law, on the other hand, prohibits censoring content on the basis of the user's viewpoint, the viewpoint of another person or the user's geographic location within Texas. Texas's statute also requires that concurrently with the removal of user content, the platform must notify the user and explain the reason the content was removed. The 11th Circuit examined Florida's law and determined that content moderation is speech protected by the First Amendment, held that the content moderation restrictions, as well as the individual explanation requirement imposed by Florida's law, likely violated the First Amendment and upheld an injunction against the law. The Fifth Circuit basically held entirely the exact opposite when it reviewed Texas's law. It held that content moderation practices are not speech, but are instead censorship that the government may regulate in the interest of protecting the public square. The court also held that even if content moderation is First Amendment protected speech, Texas's statute nonetheless survives intermediate scrutiny. The Supreme Court, in its opinion, rejected both the Fifth and 11th Circuit's opinions and sent the laws back to the lower courts. The court did so because NetChoice brought this case as a facial challenge to the statute. But in the court's view, no one had yet determined whether a substantial number of the law's applications were unconstitutional, judged in relation to the statute's plainly legitimate sweep as required to bring a facial challenge. The court noted that arguments had focused so far only on certain heartland social media applications, for example, Facebook and Twitter and YouTube, and even more narrowly still, only on certain functions of those platforms, specifically their news feeds. But the statutes, the court noted, could also apply to a broader array of services like online marketplaces or direct messaging services or rideshare applications. The court therefore directed the lower courts to conduct the analysis of the law's scope and decide whether and when its applications raised constitutional issues. The majority, however, didn't stop there. They then went on to speak specifically about Texas's law in the hopes of guiding the Fifth Circuit's future analysis of that statute as applied to services like Facebook's newsfeed. The court made clear that content moderation, the process of curating and ordering content in a newsfeed, for example, is an editorial process protected by the First Amendment, and that the application of Texas's content moderation regulations to that process probably violates the First Amendment because it interferes with that editorial judgment for the impermissible purpose of attempting to balance the marketplace of ideas on social media. In a footnote, the court also kind of nodded toward how the lower court should proceed in analyzing the constitutionality of the individualized explanation requirements by saying that requirements of this kind are unconstitutional when they unduly burden expressive activity, with a citation to a case called Zotterer. The court noted that its analysis of content moderation as an expressive activity should guide the lower court's analysis when they do it again, potentially hinting that they also think that the 11th Circuit was on the right track when it struck down the individualized explanation requirements in Florida's law as being unduly burdensome. We also saw concurrences from Justices Barrett and Jackson that are interesting in their own rights and may preview their thinking in future cases involving things like AI and TikTok even. Concurrences from Justice Thomas and Alito, on the other hand, read almost like dissents. They concurred in the judgment, but took significant issue with the majority's reasoning. I look forward to digging into this further.
If I could just jump in, I think, thanks so much, Kate, for that really helpful explanation. And I think two of the key things to take away from this case is two principles. One, as Kate mentioned, it's sort of that, I know this comes from like one of the my favorite lines from the opinion is Justice Kagan putting it that the First Amendment does not go on leave when social media are involved, because we're seeing so much of that in other cases, like across the country, where governments are treating social media like this new thing that, oh, well, the First Amendment doesn't apply here. And, that's kind of tracks the history of, like, first it was the internet itself, it was video games, or whatever the new kind of technology is that comes along. There's government efforts to restrict it, saying the First Amendment doesn't apply. And here the court saying emphatically that the First Amendment applies just as strongly to online speech as it does offline. And of course, it makes the analogy here with the social media platforms' editorial choices is just like newspaper editorial choices, just like the cable operators' editorial choices from earlier offline cases. And then the second thing that I love about this case is that it reaffirms that the government has no valid government interest in policing the marketplace of ideas. So this idea that Texas could, was trying to, adopt this regulation in order to provide a diversity of viewpoints and tilt the balance of the marketplace of ideas is just completely rejected by the court. They have a great line that it's not the job for the government to decide what counts as the right balance of private expression to, quote unquote, unbias what it thinks biased, rather than to leave those judgments to speakers and their audiences. And that's another key point that we're seeing in a lot of government regulations, where they're trying to intervene to balance and put a thumb on the scale of what viewpoints are allowed. So I think those are two great takeaways from this case.
And if I could jump into, thanks so much, Kate, and also Darpana for this really interesting thoughts. I thought I might just highlight a couple of things I really liked about the opinion, and then a couple of things that left some open questions in my mind, or maybe scratch my head. So I think these are overlapping with what Kate and Darpana said, but hopefully in a slightly different inflection. I really appreciated that the court treaded carefully in this case, or in these consolidated cases, and it was appropriate, I think, that the opinion was drafted by Justice Kagan, because the listeners may remember that last term, I think it was in the Gonzalez case, which involved a broad suit against Google for its alleged aiding and abetting of terrorist groups through its recommendation algorithms. At oral argument during that case, Justice Kagan said, these are not the 9 world's greatest experts on the internet. And so it seemed particularly appropriate that she authored this opinion, which proceeded very carefully. And in fact, in ruling on this question of whether the plaintiffs could proceed under their facial theory, took that to heart, said there's a lot here we don't know. The plaintiff in the case hasn't met the standards for a facial challenge, because we still don't know these things that need to be clarified before ruling broadly. So I thought that was appropriate. On the substance of the decision, there the two key pillars to my mind are the ones that Kate mentioned, the editorial rights of the platforms. It was nice to finally have that affirmation, because I think there had been a lot of uncertainty in the litigation below, based in part on some scattered comments by Supreme Court justices over the past few years about whether the court would consider the platforms to be more like telephone companies, which can be regulated pretty substantially as common carriers, or closer or more akin to newspapers, which have First Amendment protections for their editorial compilation of views to produce a piece of expression in its totality for its consumers. And I think First Amendment advocates were almost uniform in saying platforms are just the modern are modern versions of these kinds of media companies and are entitled to First Amendment rights. And thankfully, a majority of the court agreed. The other, which flew under the radar a little bit for a lot of people, but was an important debate within the First Amendment community, and I think it's still a little bit unresolved, but we have now hints about how the majority of the court thinks about it, is the question of whether transparency laws directed at the platforms can ever be constitutional. The plaintiff in this case and some of the amici argued essentially that the Zauderer framework, which establishes a lower standard of review for commercial transparency laws, whether that framework can ever apply to expressive companies like the social media platforms. They essentially argue that that lower standard doesn't make sense in the context of expressive companies. At the Knight Institute, where I work, we argue that that framework is actually the right one because it allows courts to appropriately balance the public interest in more information with the potential burdens that disclosure requirements might create for speech. And a majority of the court seemed to think that was the right framework to apply. I don't know that ruling is how considered that ruling was. It was in some sense dicta, and in theory open to the court in the future to re-examine or to abandon. But my suspicion is that lower courts will take that as a directive that they should, at least until the Supreme Court says otherwise, be applying Zauderer to disclosure requirements that satisfy Zauderer's thresholds. And those thresholds are laws that require the disclosure of purely factual and uncontroversial information. And if so, then the question becomes, does the disclosure requirement unduly burden speech? So really liked all of that about the opinion. Just a couple of quibbles I had, with it. One is that strangely absent from this entire opinion was any discussion of the free speech rights of the platform's users, because regulation of the platforms obviously directly implicates the free speech rights of the platforms, but it also directly implicates the rights of the users of those platforms. And that might be especially relevant when, in the court's opinion, the platforms are engaged in something that looks less expressive than content moderation. So the opinion gave some examples of things that might be different than content moderation. And it talked about the use of AI, where you're turning over content moderation decisions to AI. And Justice Barrett suggested maybe that's not expressive. Justice Kagan in the majority opinion said maybe it's not expressive when platforms curate their feeds purely on the basis of user engagement, which is actually what most of the platforms do. And even if you agree with their suggestions that maybe the First Amendment analysis is different for those functions, I'm not convinced that it is. But even if you did agree with that, certainly the free speech rights of the platform's users would be implicated because they have a right to participate in communities organized in a particular way, even if the platforms don't have a right, a First Amendment right to organize the communities in that way. I'm going to start there. I'll stop there because I'm talking for a while. But overall, I thought this was an appropriately cautious and important opinion that leaves open really important questions for the future of platform regulation.
Thanks.
Can I pose a question? And you've spoken to this, but I want to ask it in a slightly different way. Anytime this issue comes up or this discussion comes up, there are always people who say, oh, the platforms are doing nothing but using algorithms. That's not really editorial judgment. What did we learn about that issue in this decision?
Some, but not a ton. Basically, the court seemed to say that where there's a human that directs an algorithm to implement content policy or content standards, then that is still editorial judgment. But there was a distinction drawn by Justice Barrett in her concurrence that questioned whether as generative AI or the use of artificial intelligence becomes more advanced, whether the link between human decision making regarding what does and doesn't belong on a platform becomes more attenuated. And she also suggested that attenuation has a constitutional significance or could have a constitutional significance. I don't think that the technology that she describes, technology that identifies hate speech on its own without ever having been told by a human what hate speech is, or without ever been directed by a human to assess what is and what is not hate speech, exists yet. I also don't think that the idea that there is an algorithm out there that only shows people what the algorithm thinks it wants to see is necessarily something that does not have human involvement. And having been told previously that this is how you're supposed to order content, basically what I think, I think the way that platforms currently use artificial intelligence and large language models in order to help them order content and help them classify content for whether it does or doesn't violate or potentially violate particular existing standards for the community. I think the court was pretty clear that those are parts of the editorial judgment that receive First Amendment protection. But they carved out this possibility that in the future, if decisions are fully automated, there could be some different analysis for those future decisions.
And just 2 quick points to piggyback off of Professor Wermiel, your question, and as well as Alex's point about editorial judgment. The court makes clear that just because the platforms let in and allow a lion's share of content, that doesn't make, diminish the sort of editorial discretion rights that they have. And so even if they're using algorithms for most of it, if they're still using some editorial discretion in allowing, not allowing certain content or removing content or filtering it or demoting it, that's enough. It's enough that the social media platforms are excluding something. And then just a quick point, because I know we want to get on to the other cases, responding to Alex, is that, I think all of the language on Zauderer is in fact dicta, because the Supreme Court expressly declined to take cert on that issue. And, just by way of comparison at Fire, I think our approach is that Zauderer is not the right test here, because it is limited to kind of commercial speech. And I think a lot of courts and the Supreme Court and most of the lower courts are kind of expanding the commercial speech doctrine beyond what it was intended. It's supposed to only be for commercial transactions, so advertisements, right? And if you apply that framework to social media, which is not really all of social media, kind of like it's a monolithic thing, that's not really the right approach.
I think the court did take cert on that question. I mean, that was the second question for cert, was the individualized explanation provisions. I think the argument for it being dicta is that the court ruled against the plaintiffs, on procedural grounds, essentially. Although in the section of the opinion considering whether they could bring a facial challenge, which was the operative ruling, that's where they mentioned Zauderer for the first time. But it's still arguably unnecessary to the reasoning of the court's opinion. I think that's the strongest argument for it being dicta. But I think by my count, either 7 or 8 of the 9 justices seemed to think Zauderer was the right approach. But they didn't spend a ton of time discussing it, and all of the arguments that NetChoice made about Zauderer, which was not the bulk of their argumentation, because the bulk of the case was focused on the must carry provisions of the 2 laws. I think all those arguments are still going to be available to future litigants, and the Supreme Court is still going to feel free, to rule on the question. But my assumption is that as a practical matter, the lower courts will likely apply to Zauderer, because they will see that 7 or 8 of the 9 justices seem to think that Zauderer is the right approach.
Can I add one thing on top of that, though? I don't think they have to hold that Zauderer is the right approach in order to strike down the individual explanation requirements. They can apply Zauderer and basically say it doesn't even survive the lowest standard we could we don't have to choose standard of scrutiny here, because these particular provisions don't even survive the lowest standard that we could apply. And I think that's probably, from my perspective, that's correct, because these particular provisions impact editorial judgment and editorial decision making so thoroughly. Like, they disincentivize content takedowns. They disincentivize particular editorial judgments, because they burden those editorial judgments so greatly. So that's that's kind of my view, that they don't actually have to pick Zauderer for individual explanation requirements, and they don't have to pick Zauderer for every single type of disclosure or transparency requirement that we could apply. There might be there are many different ways to slice this cake, right? Of trying to get information out of social media platforms that we want to see and we want to know about. And I think one of the things we're seeing from the court here is we are going to think about each one of those things in a very specific way, and we are going to apply what we think is the right standard to each one. So I don't think we're getting the idea that like Zauderer is right for any necessarily transparency requirement, and that like, but there could be some that would survive Zauderer that it is appropriate to apply. Whereas there might be other more appropriate standards for other types of transparency requirements.
Yeah, the requirements certainly have to satisfy the threshold requirements of Zauderer, and not all transparency, requirements do, and there's still debate about whether any do. I think that's the point, the point that Fire made in its submissions. I agree that at the very least, Florida's individualized explanation requirement would violate even Zauderer because it was extremely burdensome. It would require the platform to provide a thorough rationale for any decision to suppress speech, which would include not just clear content removal decisions, but any deprioritization of speech. It seemed, at least in the lower court litigation, that the platforms could comply with Texas's individualized explanation revision much more straightforwardly, because it didn't seem to require a thorough rationale. It seemed to essentially require that the platforms point to the provision in their terms of service that users allegedly violated when they decided to actually take down, not just deprioritize, but actually take down speech, which is now something that the platforms, I believe, have to do in complying with EU law, which is a point that Justice Alito made in his concurrence in the NetChoice case. It's not as obvious to me why that would be unduly burdensome, but I think I assume that's part of what will be litigated in the lower courts, and NetChoice will have the opportunity to make the case both that Zauderer doesn't apply or shouldn't apply, and even if it does, that the requirements are too burdensome.
All right, there are questions in the Q&A that will bring us back to this subject, but why don't we get through a few of the other cases first, and then I think we'll have a lot more opportunity to talk about this very important issue. So Darpana is going to tell us about the National Rifle Association versus Vulo.
Thanks, Stephen. In this was a major victory for free speech and the rule of law. We have a unanimous ruling by the Supreme Court that reaffirms that indirect censorship is still censorship, and it still violates the First Amendment. So in this case, the NRA had sued the former head of New York's Department of Financial Services for using her authority to kind of go behind the scenes and pressure regulated banks and insurance companies to cut their ties with the NRA. And it had done so specifically because it disapproved of the NRA's pro-gun advocacy. So in the wake of the Parkland, Florida shooting, the department told these third parties in closed-door meetings that it would not enforce technical insurance violations against them, like insuring intentional criminal acts or providing affinity insurance without the proper license, if they stop doing business with the NRA. And the department also issued guidance letters and a press release urging all insurance companies and banks doing business in New York to consider their quote-unquote reputational risks and sever ties with the NRA. The Second Circuit dismisses the complaint, ruling that New York's actions are permissible government speech and legitimate law enforcement efforts, and that even if there was a First Amendment violation, the officials were entitled to qualified immunity because this was not clearly established. The Supreme Court granted cert on the first question about whether there's a First Amendment violation, but not on the qualified immunity question. So we'll stay tuned for what happens in the lower courts when it gets remanded back. In an opinion authored by Justice Sotomayor, the Supreme Court rules that the NRA sufficiently stated a First Amendment claim. And why it makes clear that while the government is free to criticize the NRA and pursue what were concededly violations of insurance law, what it can't do is threaten enforcement to punish or suppress the NRA's pro-gun advocacy. And in doing so, it reaffirms a 60-year-old ruling in Bantam Books v. Sullivan. And, it's, textbook black letter law that the government cannot directly censor views that it disfavors. And in Bantam Books, the government says, well, the government can't do indirectly what it can do directly. And so it can't indirectly censor views by punishing or suppressing speech it disfavors by attempting to coerce third parties or private parties. Here, the court applies the 3 factors of Bantam books, which are the first sort of looking at what is it, what kind of authority do the government officials who are alleged to be engaged in coercion have? Second, it looks at the nature of those communications, like what did the government officials actually say or threaten to say? And third, the reactions of the third parties alleged to have been coerced. Significantly, after Bantam books, a lot of the lower courts came up with their own multi-factor tests for, how do you assess when government persuasion kind of crosses the line into unconstitutional coercion? And here the court does not endorse any specific test. Instead, it cautions that, these tests provide helpful guides, but all of those kind of factors are non-exhaustive. And really, it's a totality of the circumstances inquiry. And where the Second Circuit kind of went astray was treating these factors rigidly and looking at the allegations in the complaint in sort of isolation, instead of asking sort of whether, if you take all the allegations as a whole, if the challenged conduct conveyed a threat of adverse action to punish or suppress the plaintiff's speech. So we don't get a clear test from the court, but we have a good example of what not to do, what the Second Circuit did here. And most importantly, the government is reaffirming that there's a huge difference between the government using its bully pulpit, so to speak, and the government engaging in just flat out bullying. And this line is especially interesting, as we'll discuss in the Murty case, which I think Alex will be talking about later.
Thoughts, comments about Vulo?
I agree with Darpana. This was a nice affirmation of a really important basic First Amendment principle. And, when the case made it to the Supreme Court, it seemed, I think, to most First Amendment observers, like a really straightforward First Amendment case. Regulators seem to be trying to induce private actors to punish disfavored speakers. And that has been unconstitutional for at least the last 60 years, under the Bantam Books decision. I think one thing that First Amendment advocates had been hoping for from this term, whether in the NRA versus Vulo case or in the Murthy case, which we'll discuss in a minute, was just greater clarity on where the line is between persuasion and coercion, because these things do not, they exist on a spectrum. They're not a binary. Some things feel coercive because they're so persuasive. Moral condemnation. One of the things in the Murthy case that we'll talk about is President Biden saying the platforms are killing people. That's a moral condemnation that might feel very coercive, but is it coercive in the constitutional sense, or is it merely persuasive? And the Supreme Court, in neither of these cases took the opportunity to provide much greater clarity. So unfortunately, these, the standard will be a case by case, one for the foreseeable future, where the lower courts, like the Second Circuit, come up with a set of factors to look at in deciding whether something is not just persuasive but coercive. And that's, that will be the state of the law, which, again, I think is unfortunate that we don't have greater clarity, but the Vulo case was a welcome reaffirmation, at least, of the original Bantam principle.
Anyone else? Kate?
I don't really have that much to add, other than I also liked the decision and found it to be a good reaffirmation of what I consider to be a really important case. I think the only thing that I would say is, like, I would echo Alex's, I won't call it disappointment, but his observation that there wasn't additional clarity. I think we were all kind of hoping for that, like, oh, maybe you could just at least tell us if it's a close call, the call goes against the government. Tell us something like that. Like, give us at least that. But we didn't get any additional clarity. We just got a reaffirmation of important precedent. That being said, it doesn't mean we are done with what clarity could look like, right? Now we can turn to the government and say, like, it is your responsibility to not coerce private actors to censor constitutionally protected speech. If you do want to continue having important and productive conversations with private actors, like, for example, social media companies, what are the things you could do to ensure that those communications fall on the right side of the line? And are there things that you could do that could bind existing government employees to that sort of process? I think there probably are. And I think that that's a discussion worth having with with the White House, with legislators, et cetera. So I don't think we have to leave it at Volo and wait for the next Supreme Court case. We can try and get clarity from other government actors, since it is their responsibility not to violate the First Amendment.
Anybody know if there's another case that might call for that clarification on its way to the court?
Well, the Murphy case might end up back there. It's possible. Yeah. We'll talk about that in a minute, and there may be some other ones in the works. Can I just mention one other thing? So one proposal I also really like that is a bit prophylactic is made by the Cato Institute. Cato put out a proposal for Congress to pass a requirement that the government be transparent about its efforts to pressure platforms to take down supposed disinformation or any kind of information on their services. And they have exceptions for things like national security, where you wouldn't want the government to be, where it might tell a platform, this account that looks legitimate is in fact being operated by a terrorist group, but revealing that publicly might, disclose information the government has. It has exceptions for those sorts of things, but is generally geared at deterring these kinds of pressure campaigns by imposing a transparency obligation on the government. And that seems like a sensible idea to me. The details matter, but it seems like a good approach.
How does that play out? The government puts out a press release saying the Center for Disease Control has contacted Facebook today to complain about misinformation that Facebook is posting, or?
I think I think if I remember correctly, Cato's proposal would have the government submit disclosures to Congress, most of which would also be made public on some kind of government website. And the ones I think that wouldn't be public would be the ones that implicate some legitimate interest of the government in secrecy. I think something like that is the proposal.
All right, Darpana, final comment on Volo?
Yeah, just to add to that, FIRE also has a model bill on this. It's called the Social Media Administrative Reporting Transparency Act, the SMART Act. And it's basically addressing this kind of what folks have termed job owning, where the government's using informal efforts to coerce private actors into action. So yeah, you can check it out.
Sorry, I hadn't seen that one. If I'd seen that one, I would have mentioned that.
That's okay.
Stay tuned.
Yeah, stay tuned.
All right, Alex, let's turn to you for Murphy versus Missouri.
So Murphy versus Missouri was another, job owning case, to use the term that Darpana introduced. Job owning, just the idea that the government might try to pressure speech intermediaries into silencing speech. That case was brought by 5 social media users in 2 states, Missouri and Louisiana, who alleged that the Biden administration had engaged in a widespread effort to pressure the social media platforms into suppressing speech about the 2020 election and about the pandemic. And the plaintiffs in the case sought they filed a case, and then they sought a preliminary injunction that would restrict the administration from engaging in that kind of pressure, from pressuring the platforms to take down speech. The Fifth Circuit, the lower court, the district court granted that preliminary injunction. The Fifth Circuit affirmed it, but narrowed it, largely preventing the Biden administration from engaging with the platforms and their content moderation decisions. And then the Supreme Court took the case up for review. And when it got to the Supreme Court ended up resolving the case entirely on the question of standing by asking whether the plaintiffs had demonstrated that they were, that the injuries they complained of were in fact attributable to the government, and that they would be redressed by the preliminary injunction that they sought. And it was an opinion that started by explaining the standards that apply when somebody is seeking a preliminary injunction, and specifically when they're alleging this kind of job owning. And so it melded those two together and said that the specific question for these plaintiffs is whether they can demonstrate, and I'll just read from the opinion, a substantial risk that in the near future at least one platform will restrict the speech of at least one plaintiff in response to the actions of at least one government defendant. It's a pretty high burden. Part of the reason the burden is so high is because plaintiffs in these cases are essentially limited to seeking forward-looking relief, prospective relief. followers of the development of constitutional law will know that the context in which the Supreme Court will allow you to sue the government for damages for violating constitutional rights under the so-called Bivens doctrine, are getting narrower and narrower. And if you're suing states under Section 1983, which is the statutory equivalent, there are immunity doctrines that make it really challenging. And so plaintiffs in these cases are often limited to seeking prospective relief, which will make it harder for them to demonstrate standing, especially in cases like this one. And the court ultimately answered that question in the negative. It said at the end of the day, the evidence that the government was responsible for the suppression of the plaintiff's posts on social media was weak. And that was the word that the court used, and it used that word multiple times. And it explained why it thought it was weak, mostly by saying that some of the alleged censorship actually predated the supposed censorship pressure campaign by the Biden administration to take down speech. So some of the specific examples of suppression of posts of the plaintiffs, came in 2020, but the pressure on the platforms that was allegedly responsible for that suppression didn't happen until 2022. That's one of the examples the court gave. It also said that the platforms often, or maybe even usually, took down the speech at issue not as a result of government pressure, but in enforcing their own independent editorial policies about the speech on their sites. And that was unsurprising because in the midst of the pandemic and the 2020 election, most of the platforms adopted policies against medical and electoral disinformation. And the court didn't seem convinced that the plaintiffs had evidence that the platforms had either adopted or enforced those policies as a result of government pressure. And so at the end of the day, it threw out the case on standing. It was also, and this gets to the procedural point I mentioned earlier, it was also especially skeptical of the possibility that the injunction the plaintiffs wanted would redress their injuries. And it pointed in large part to the fact that the pressure campaign at issue had, and here again, I'll quote from the court's opinion, had considerably subsided by 2022. I point that out in part because it shows how difficult it is to make out these kinds of claims, which, especially when you're talking about broad pressure campaigns, by the government directed at speech platforms, might worry you if you're worried about how vulnerable these platforms are to government pressure, because you're almost always going to learn about these things after the fact. You're almost always going to be litigating them in the years afterward. And, the urgencies of the moment that caused the government to engage in the pressure campaign might, and as they did in this case, have subsided. And so it'll be hard to make out a case that you're entitled to an injunction against, against future pressure by the government. So I think this was, ultimately the correct decision. I think the conspiracy theory that the plaintiffs put forward was unsubstantiated. And there's a lot of commentary in the lead up to the case, digging really closely into the allegations they made, and they all, none of them really seemed to pass the smell test. Not even the dissent in the case is a 6-3 decision. Not even the dissent in the case really took up the main cause of the plaintiffs. They focused very narrowly on, one plaintiff's set of allegations and didn't defend the broad theories that most of the plaintiffs had put forward. But it's unfortunate, even though I think the court correctly resolved this case, it's unfortunate again that we didn't get much advice on how to apply the Bantam framework of coercion versus persuasion, particularly in the context of social media, where the risks of government pressure, I think, are higher because the platforms are choke points for public discourse. And so it's easier to pressure them into suppressing speech. And when you do, you can be very successful by pressuring just a small handful of them. And they're also vulnerable because the platforms generally don't care all that much about any individual posts on their sites. They have billions of posts that go up every single day. And they have very good reasons for wanting to maintain good relationships with the government. And in the balance, they're probably more likely to succumb to government pressure than, for example, book distributors or book publishers, as was the case in the original Bantam case from 1963. So that's the Murthy case.
I'd just jump in. Now, there was a huge, voluminous record below, and I'm not definitely familiar with all of it. I think they said it was, what, 26,000 pages? But I do think there's something there in the dissent. They chronicle, and I agree, they only focus on one plaintiff, but all you need is one plaintiff to get standing. So you have one plaintiff, and the ties between her and the White House communications and the Surgeon General's communications and how they coerced Facebook into censoring her were just pretty alarming. And Justice Alito, authoring the dissent, focus and chronicles that, voluminous record and shows what the district court found, and the district court, the standard on review is, were these findings clearly erroneous, finds a far-reaching and widespread censorship campaign conducted by high-ranking federal officials. And I think one of the points, getting back to the Vullo case that Alito notes, and I think this is an oral argument too, but in the Vullo case, New York's attempts were just blunt, and I think what Justice Alito turned were kind of ham-handed. Here, you have a little more sophistication, a little more subtlety, but it still seems like coercion. And I think the dissent rightly notes that it seems like what we're doing is putting a kind of giving government officials a roadmap of like how you can coerce private actors to suppress speech and get the speech you want without finding yourself liable for it. So this decision was a little concerning. I worry about what it says for future First Amendment plaintiffs, especially, as Alex notes, when you're suing the federal government and you're kind of precluded from getting money damages under the Bivens doctrine, at least as it stands now. And even against state officials, the qualified immunity doctrines and other doctrines make it really hard to ask for money damages and to get retrospective relief. So, what is it that we need to show? And I worry that the majority's explanation of, elucidating the standard for standing kind of really conflates itself into getting to the merits. I mean, all we need is kind of a threshold, an injury caused by the defendant that can be redressed. And by really putting in kind of an elevated standard requirement, it seems like it's notching up that standard a little bit. So we'll stay tuned for, I'm sure government officials will be bringing up, challenging standing and all sorts of First Amendment violation cases after this.
Kate, did you want to weigh in?
Sure. I don't have much to add other than I want to talk a little bit about the plaintiffs asserted a right to listen theory of standing, and the court discounted it in a way that I found concerning, because to the extent that you want protections for the rights of users of internet platforms, this is a theory that, generally speaking, is appealing. It's appealing, for example, for the case being brought by TikTok users, that they have a right not just to use TikTok as a platform for engaging in their own speech, but also to listen to speech that is specifically distributed via TikTok, because the amalgamation of users and speech within TikTok is not reproducible elsewhere. But the court in this circumstance essentially interpreted or articulated a pretty narrow view of what the right to listen covers, saying that the court has recognized a right to receive information, but the cognizable injury only happens where the listener has a concrete and specific connection to the specific speaker. And I am a little bit concerned that that's a pretty narrow interpretation of what the right to listen should ideally be. I'm not sure how controlling that is going forward, but it was one of the things that stuck out to me as the rest of the opinion I was kind of okay with. I was actually pretty encouraged by the fact that they, since this came out prior to Net Choice, that they credited platforms' existing editorial decision-making processes as a reason that, you cannot necessarily assume that just because the government is communicating with them about particular content moderation decisions or categories of content upon which platforms take action, that's necessarily the government coercing particular speech decisions. I thought that was probably right. But when I got to the right to listen, piece, that was somewhat concerning to me when I thought about it as applied in the future.
I just had one thing too. So I mean, I agree entirely with Kate, but I think, this exchange between the three of us, I think highlights one of the difficulties with the coercion framework. Because the court has made clear that the government, is entitled, in part because because of the public need to have a government that can govern, to express itself, and to do so sometimes forcefully. It's unclear, though, if you talk to people who have studied the First Amendment, and certainly to the litigants who litigate these cases, when something that is expressed really forcefully is just the government expressing itself, or is in fact threatening something, is coercing something. And so that's in part why it'd be especially helpful to get clarity from the court. Because, for example, one of the signature complaints that the plaintiffs in the Murthy case made was that when President Biden said the platforms are killing people, he said it very publicly, that when he said that, that was a tacit threat that the government was going to regulate the platforms. I don't think that's a threat. To my mind, that's the government expressing moral condemnation. The government needs to be able to galvanize public opinion, to steer public attention toward the issues that it thinks of as important. But it was probably received by the platforms as, it probably hurt their bottom line. They probably felt that comment. But did they feel it in a kind of persuasive way, a way of, did they receive it as a strong moral condemnation, which might be permissible, or did they receive it as a actual coercive threat of government power, which would be unconstitutional? To my mind, I don't think it would have been legitimate for them to say it was coercive. I think it was persuasive, but there's a division of view on this question. And you have, within the First Amendment community, a division of views on this question, which is why it would be nice to have greater clarity. But I also think, and this is the point we made in the amicus brief we filed in the case, and we actually pointed out to one exchange between White House officials and Facebook that we thought reached the level of coercion. Although whether that could be tied to a specific suppression of speech, I don't know. We didn't dig deeply enough into the record to answer that question. But one thing we argued in our brief is that we shouldn't expect the Bantam framework, the coercion framework, to address the problems of the concentration of private power over public discourse, because that concentration exacerbates the problems of job owning, because it does make the platforms into these very attractive targets for pressure campaigns, and it makes them likely to yield because they are so large and have such broad interests, and because they care about their relationship with the government, right? They care about their statutory immunity under Section 230, which essentially enables their business model by immunizing them for the speech of their users. And so they're likely to go along, even with pressure campaigns that don't reach the level of coercion. They're just likely to go along with pressure, any kind of pressure, because they just want to play nice. And to my mind, we can only expect the Bantam framework to address that problem to an extent, because some of that problem is in fact attributable just to the concentration of power. And if we want to address the part of the problem that emerges from concentration, we should address concentration through antitrust law or competition policy law, laws that come from economic policy that would make it easier for, there to be competition in this market. So we don't have just a handful of platforms that decide who can say what and what will be heard in public discourse. Because I think that's fundamentally corrosive in a democracy. And this is one of the reasons why it is corrosive, is because you have single points of failure that don't act in the best interest of their users.
So I want to move on to other cases, but let me ask one last quick question here. Robert F. Kennedy Jr. would like to become the face of the future of this issue, saying that he's being affected by government criticism of his vax or anti-vax positions. Is that issue resolved by this decision? Not really, right? Could be where we go next.
I'm not familiar with his specific allegations. If he's just complaining of government criticism, then that's not going to be enough. If he's complaining of, government coercion of the platforms, then it could be, if he can actually, make out the case. One thing that's interesting about the case, though, that is relevant to that, the plaintiffs in the case had actually essentially asked the court to abandon the Bantam framework. They had asked the court to hold that anytime the government puts pressure on a speech intermediary to take down speech, even if it's not coercive, that's unconstitutional because the government just doesn't have a legitimate interest in doing so. especially if it does it behind closed doors. And I have some sympathy for the argument that, especially when the government is acting behind closed doors, the risks are so high that we should have a prophylactically protective First Amendment rule. I have sympathy for that argument, but the court essentially ignored it. It didn't say anything about it. It seemed to assume that the Bantam framework was the right framework. It obviously reaffirmed it in Vulo. And so it seems unlikely to me that they're going to abandon it in a future case. But worth pointing that out, because that was the kind of broadest theory that the plaintiffs advanced.
All right. Go ahead.
Actually, just a real quick note on that. I agree that it is a little frustrating. We don't have a clear test for coercion, but I think, I think, Alex, you're right that, this isn't going to necessarily be a problem that has to be fixed or can be necessarily fixed by the courts. But kind of comparing Vulo and what happened here, especially if you look at Justice Alito's dissent, like, it's hard not to see direct parallels. Like in Vulo, it's, if you don't sever your ties with the NRA, we're going to pursue all these regulatory enforcement actions against you. Here, at least in that one example with the one plaintiff they had, Plaintiff Hines, if Facebook, if you don't solve your misinformation problem, we're going to unleash the regulatory authority of the White House and boost our antitrust efforts and get rid of Section 230 immunity. And I think Alito even throws in sort of the relationship of the social media platforms with the White House and how they're kind of dependent on them for data privacy issues pertaining to the EU. And that so I think what the problem is exactly what Alex said, is sort of this interrelation or the dependency of these companies and of social media companies on the White House for certain benefits and things otherwise. And then when does that cross the line? So I'm hopeful that I think the problem specifically in Murty was kind of this conglomeration of too many social media apps and trying to draw that specific line to like defendant to plaintiff to government to the social media apps and what happens going forward. This was kind of a unique situation with the pandemic, a once in a lifetime pandemic. It'll be interesting to see if there's any misinformation related to the 2024 election, what we can see.
I would just add that
back to you. Go ahead, Kate. We need to cover two more cases, but go ahead.
Very quickly, I don't want to discount practicality on the part of the court here. That they were looking at a situation where maybe every single time a government actor talks to a social media company, we're going to have a case, and we can't have that. So we have to come up with what it would take to even get you into court, and that is what we are explaining in this case. So I think that's part of just a practical view of what they were trying to do in Murphy.
All right, thanks. Alex, back to you to talk about O'Connor Radcliffe and Linkey.
I'll be very quick here. So these two cases, the court took up to answer the question of when the First Amendment applies to public officials who use their social media accounts in a way that maybe is related to their official duties. And the one that they decided was Linka versus Freed. O'Connor Ratcliffe, they just remanded for reconsideration in light of the decision in Linka Freed. So I'll focus on Linka Freed, which was a unanimous decision. So James Freed, he was a city manager in Port Huron, Michigan. He had a Facebook account in 2008 when he was appointed to become city manager 6 years later in 2014. He started to use his Facebook account a little differently. He started to use it a bit for things related to his job. He continued to post about his personal life, but he also posted information about his job. He shared updates about city work and functions. He solicited feedback from the public on the job that he was doing. And ultimately, it became a place where he was criticized by Kevin Linka, who criticized the way the city had handled the pandemic. Freed ultimately blocked Linka, deleted some of his comments and blocked him from the account. And Linka then sued under Section 1983, alleging that blocking violated the First Amendment because Freed's Facebook account had essentially become a public forum from which Freed couldn't block him, consistently with the First Amendment. The court, took this question up, and the crucial difficulty that the court grappled with, the kind of central tension of these cases, is the fact that there are free speech rights on both sides of the equation. Under Hornbook First Amendment law, the public has a First Amendment right to participate in forums that are established by the government, and they can't be excluded from those forums on the basis of viewpoint. On the other hand, government officials don't lose their First Amendment right to speak as private citizens, even when they're talking about matters that concern their official duties. And the Supreme Court has been clear about that. And the test that the court came up with for helping to distinguish these two things, for deciding when a public official is acting in their official capacity and not in their private capacity, was to ask two questions. It said, and I'll just read, this is the core, this is the core of the court's decision and will be the framework going forward. It said, a public official's social media activity constitutes state action only if the official, one, possessed actual authority to speak on the state's behalf, and two, purported to exercise that authority when the official spoke on social media. So the official needs actual authority to speak on the state's behalf and needs to be exercising that authority with respect to the challenge being made by the constituent or whoever is being blocked from the account. The court said a few things that are helpful in understanding how these two inquiries apply. On the first, the question of actual authority, it said actual authority comes from one of two places. It either comes from written law, statutes, ordinances, regulations, or it comes from custom and usage. And it defined the latter one pretty narrowly. It said that custom and usage encompasses, quote unquote, persistent practices of state officials that are so permanent and well settled that they carry the force of law. It said pretty importantly that the authority to speak does not need to be specific to speaking on social media. It can be a general authority to speak that encompasses or necessarily encompasses the authority to speak on social media. And the court said that that was much more likely to be the case for high-level officials who often have the authority to speak generally on behalf of the state or the city. But the analysis might be different for lower-level officials who might not necessarily have that authority. On the second inquiry, again, the one about whether the official was exercising that authority, the court established a heavy presumption, although it said not irrebuttable, that if a public official labels their account personal or includes a disclaimer that they are, again, there's a heavy presumption that they're speaking in their personal capacity. It said that for mixed accounts where you have personal and official speech going on, it's going to be a fact-specific analysis, and it's going to depend on the function and context of the post. It gave some factors that courts can rely on, but it didn't purport to be exhaustive. It said that some factors indicating state action would be that the post invokes state authority or has legal effect, or includes information that's not available elsewhere. Also, it said if the official is relying on government staff to run the account or to come up with the post, that's indicative of state action. On the other hand, it said if all the public official does is repeat information that is available officially elsewhere, that's not good evidence of state action. And then I think pretty crucially, it said the nature of the technology matters. It said if an official is deleting a comment, so in the case of Freed, he deleted Linka's post on some specific comment, then the only posts that are relevant in deciding whether the official was exercising state action are the comments from which the posts from which the comments were deleted. But it said if the official is blocking somebody entirely, then everything on the account matters, because blocking them entirely will prevent them from accessing not just their private posts about their kids' soccer games, but also whatever official posts happen to be there. And so courts will, in that context, need to ask whether the blocked individual was trying to access some of those other official posts, even if there are, say, an overwhelming number of private posts. I think this was an important case in affirming kind of something that Darpana said earlier, which is the First Amendment continues to apply in social media, even when politicians move there. They can't avoid the strictures of the First Amendment and public forum doctrine by moving those forums online. I have two main quibbles with the opinion. One is that I thought that the discussion of custom and usage was a little bit narrow, and I hope that courts don't apply it narrowly, especially because this test, whether there are persistent practices that are so permanent and well settled, seems a bit ill-suited to social media, which is new. And these customs and usages are being newly established as politicians take advantage of social media. My other quibble is this heavy presumption for designating accounts personal. I worry that that's going to create an opportunity for mischief for public officials to, use their nominally personal accounts to build up large followings on those personal accounts on the basis of their public duties, have those accounts become the de facto forums for public discussion around their official responsibilities, but then sanitize them of dissent and relegate the dissenters to the nominally official counts, which will become, which will be smaller forms and stagnant ones. And it seems unfortunate to elevate the formal designation of personal over the functional analysis into, well, is it in fact personal or is it in fact official? But, it remains to be seen, obviously, how courts will apply these standards. And, we're following these cases closely, as I know, CDT and FIRE are. So, but that's the Linka case.
All right, I think we're going to run out of time to answer questions, but Darpana, can you tell us about Gonzalez versus Trevino in about 2 minutes?
Yes, I can. And can I just jump in real quick and agree with Alex on the two quibbles? But when I went back, that first thing about the custom and usage, at first I was like, what? That makes no sense in the social media context and internet. And I went back and I read it again. And at least the way I interpret it, and I hope that like lower courts kind of do as well, is that when you look at that first threshold inquiry about, and especially custom usage, the only question is, are making official announcements actually part of the job? Is there a well-settled practice of speaking on behalf of the government? Not necessarily speaking for the government on social media. And then you only look at social media for the second one. So I'm hopeful courts will not overread that too much. Getting to Gonzalez, this was another First Amendment victory. It's a case about First Amendment retaliation claims for retaliatory arrest. And in this case, we had Sylvia Gonzalez, who, after winning an election to be on the city council of Castle Hills, a town in southern Texas, started a petition to remove the city manager from office based on complaints she had heard during the campaign trail. After a heated discussion on the petition during city council meetings, the mayor had asked Gonzalez for a copy of the petition, and she said she didn't have it. Turns out it was in her binder. She claims it was misplaced. The government complains she intentionally hid it. The mayor then refers the matter to the police, who, after a month-long investigation, charge her with violating an anti-tampering statute that prohibits a person from intentionally removing a document or a government record. A magistrate judge actually issues a warrant for her arrest, but the DA ultimately dismisses the charges. Not surprisingly, Gonzalez sues, saying, this is just, I'm being retaliated against for organizing the petition in the first place to remove the city manager, and that violates my First Amendment rights. Included in her complaint, she included a survey of misdemeanor and felony data for the last decade, showing that Texas's anti-tampering statute was never actually used in the county to criminally charge someone for this kind of for action, like trying to steal essentially a non-binding or expressive document. Gonzalez claims that this shows that the survey data is evidence that the defendants engaged in a political vendetta by bringing this sham charge against her. The district court denies defendants' motion to dismiss. The Fifth Circuit reverses, saying essentially what's a former Supreme Court holding in Nieves, saying that an exception to Nieves to the probable cause bar for bringing retaliatory arrest claims didn't apply because Gonzalez didn't have any quote unquote comparative evidence that other individuals engaged in the same criminal conduct were not arrested. We get a per curiam decision out of the Supreme Court that again, reverses the Fifth Circuit. Just wrong, Fifth Circuit, trying to demand virtually identical and identifiable comparators goes too far. Nieves is all about establishing a probable cause bar for retaliatory arrests, which are a little bit different than just general First Amendment retaliation claims. There's some different considerations there. But in Nieves, the court recognizes what they term a limited exception for where a police officer will have probable cause to arrest, but they typically exercise their discretion not to do so. And in Nieves, they give the classic example of a vocal critic of the police getting arrested for jaywalking. Now, if that happens, chances are maybe, even though there's probable cause to arrest him for jaywalking, because most people are not arrested for jaywalking, it stands to reason that maybe there's something else going on here, and retaliation is really what's at play. The court in Gonzalez makes clear that to fall within that exception, a plaintiff has to produce objective evidence, but that evidence does not have to be identifying a specific other person who's a comparator who was not arrested. So I think that is a win for free speech rights. The survey data is permissible because it's basically showing that the fact that no one has ever been arrested for engaging in that same kind of conduct, especially where you have a criminal prohibition that's longstanding, makes it more likely that the officer declined to arrest someone for engaging in that conduct in the past. Justice Alito issues a concurrence, and he's basically writing to kind of further provide guidance on the court's opinion. I think, I don't know, we're running out of time. So his concurrence has some troubling aspects about, applying the Nieves framework. I think he reads it a little too narrowly. Just by giving one example, I think he puts a lot of focus on, well, if a magistrate judge kind of signs off on a warrant, that's kind of a clear indication that, maybe it's not retaliation. There's a lot of other government actors when you have a criminal proceeding. But of course, in Nieves itself, a magistrate judge signed off on the warrant. So, yeah, I think we'll stay tuned to see how this decision is applied by lower courts. But I think it's great to reaffirm that you don't need the Fifth Circuit's view was very narrow and what the Supreme Court calls overly cramped reading of that important Nieves exception.
Thank you. I'm going to turn to Q&A and maybe see if we can answer one question that kind of focuses on the question of hate speech. Is there a line where someone says lynching blacks is a good idea, or guess the Jews, or some other provocative speech? And maybe we can take a crack at answering that, and that probably will be about all we have time for. Anybody want to start?
Yeah, I think there's just a common misperception that hate speech, broadly is viewed as is not protected speech, and that's just simply not true. Hate speech is actually protected. What is not protected, though, are actual threats, true threats, or an incitement to violence. So the question is that speech actually going to incite someone to violence, or is it a true threat, meaning, you're actually threatening someone that's going to be take violence? And of course, conduct is not speech. So there are certain well-defined narrow exceptions to the First Amendment, but broadly construing speech that we don't like, or that may be objectionable and vilifying and just horrible speech that in a civil society we disagree with, it's still protected under the First Amendment.
Can I add one thing to that, which I totally agree with, which is that there's as soon as people hear that, they often then ask, well, isn't this hate speech all inciting? And the Supreme Court has defined those categories of incitement and true threats very, very narrowly. An incitement needs to be an incitement to imminent lawlessness. And the Supreme Court has rarely ever found that standard to be satisfied. And it seems almost inconceivable that it would ever find it to be satisfied by a general hate speech. There's also another category called fighting words, which has almost been read out of existence as narrowly as the court has defined it.
All I'd add on top of the perfectly accurate and good summaries that I've heard so far is I'd like to draw the line between what the government can prohibit, what is protected by the First Amendment, and what the platforms do. The platforms have their own editorial judgment, and very often they have decided that hate speech, as each of them defines it, and they all have their own definitions, is inappropriate in part because for their platforms, in part because it deters participation of the groups that are often subject to that type of speech. So Jewish people, Black people, LGBTQ people. Platforms do make an effort to reduce, suppress that type of content directed at those groups, often in order to regulate and make their platforms useful spaces for everybody to engage. But that is very distinct from what the government can require or what the government should ever be able to require.
That's great, Kate. Just a final note on that. We have a case Fire is actually challenging in the Second Circuit now about a New York law that New York, the government, is requiring websites and social media platforms to have a hate speech policy and disclose what their hate speech policy is. And so we are challenging that because it is government, compelling social media platforms to put on certain speech and, or to put on their policies about hate speech and, what is hate speech anyway, and adopt the government's view of what hate speech is, and that hate speech is problematic. So stay tuned on that.
And we're going to make that the last word. Thank you all for joining us. Thanks to our panelists for this wonderful and enlightening discussion. We do these programs as often as we can, not just on speech issues, but on all civil rights and civil liberties issues through the section of civil rights and social justice. Our webinars are usually free and simply require registration to have access and involve advocates from all over the country. Again, thank you to Darpana, to Kate, to Alex. I thought this was very informative and appreciate your efforts, and wish everybody the best of luck and have a great day. Thank you so much.